We start here this hour. Judgment in the case involving President Jacob Zuma as well as Cyril Ramaphosa will be handed down today. Ramaphosa is seeking to interdict Zuma's private prosecution application against him. He says Zuma's pursuit of this infringes on his rights constitutionally and the country as a whole. eNCA reporter Moloko Moloto is watching this for us and joins us live. Good morning, Moloko. Very important day in our courts this morning. We're expecting that all-important judgment. Just remind us of what the orders are that the president seeks here. It was an urgent application. He wanted to be excused from proceedings, but he also wanted to interdict the former president. Just remind us of the facts of this case.
Good morning, Mfundo. Indeed, it's Judgment Day. The President, Cyril Ramaphosa, will know today whether the High Court in Johannesburg agrees with him. He made an application, an urgent one, to this court, and it was heard on Thursday last week. Essentially, his application is divided into two parts. Part A, he's asking for the court to urgently or immediately interdict Jacob Zuma, the former president, from proceeding with the private prosecution. You'd recall that the former president managed to get a summons from the High Court criminally charging President Cyril Ramaphosa regarding the president not instituting an inquiry into the behavior of senior prosecutor Billy Downer. You'd recall that Mr. Zuma tried through the NPA to charge Mr. Billy Downer, but he also tried to charge journalist Karen Mon because he believed that Advocate Downer has actually leaked his medical certificate to Karen Mon. Now, the NPA decided that there's no case, and therefore it's not going to charge those two or prosecute those two or anyone regarding that matter. Now, Mr. Zuma then got a non-prosecution certificate from the NPA, which indeed confirms that they're not going to charge anyone regarding that matter. And he used that particular non-prosecution certificate then to criminally charge President Cyril Ramaphosa. And Part B of the president's urgent application before this court is anchored on that particular non-prosecution certificate, because the president is saying that that non-prosecution certificate from the NPA does not concern him, does not even mention his name, and he was not even part of the people who leaked that particular certificate of the former president, the medical certificate. He's saying he only knew of that particular matter on the day the former president wrote to him, asking him as the president to institute that inquiry. Now, because the president did not institute an inquiry into the conduct of the top prosecutor, Billy Downer, then Mr. Zuma decided that the president must be held criminally liable for not instituting that inquiry against Billy Downer. So the president is therefore saying that if this particular criminal matter against him is allowed to proceed, he will suffer irreparable harm because he would be in the dock as president of the republic, and this will also affect the country. But Mr. Zuma is saying, you've been charged anyway, because you'd recall, Mfundo, that the summons was issued on the 15th of December, a day before the ANC National Conference last year. And as matters stand, should the High Court today turn down the president's application, he would then be expected to appear in court on the 19th of January. It would be on Thursday to answer for criminal charges. So that is what actually brings us here today, and the judgment, as you have said, is expected to be handed down by starting from 9:30.
I just want to take you back to last week's proceedings. We do know that Advocate Vuyani Galwane had sought to join as amicus curiae, friends of the court, but unfortunately he was rejected. His application in that respect was rejected. Rather, he was advised that perhaps he could join court proceedings on Part B because they felt that the papers that he had brought forward were quite scholarly and worth actually debating or engaging.
Yes, indeed. Advocate Vuyani Galwane SC was representing some foundation which wanted to be an amicus curiae or friends of the court, but he did not succeed in convincing the court because the court felt that, look, in fact, it was the president and the president's lawyers as well as the lawyers for the NPA. They felt that for that company or that foundation joining as the friends of the court, particularly with regard to Part A, which is about the president seeking an urgent interdict to stop Mr. Zuma from privately prosecuting him on Thursday. Then the court said, ruled that there's no need for that foundation to join the court as friends of the court, specifically on Part A. There's no way it's going to assist the court in as far as that Part A is concerned. But regarding Part B, which is about the validity, the constitutionality, the legality of the non-prosecution certificate which Mr. Zuma is relying on to prosecute the president, he still has to make an application so that he can join as a friend of the court regarding Part B. And that Part B argument, of course, it was not ventilated in court on Thursday. Now, we also know, obviously, that the JG Foundation, Jacob Zuma Foundation, was unhappy, Mfundo, at the fact that initially the High Court or this urgent application by the president was allocated to one judge, and a decision was then taken later that it has to be a full bench, meaning the deputy judge president is part of that. 3 judges heard that matter on Thursday, and Mr. Zuma, or at least his foundation, was not happy with that, casting aspersions and doubts on the intentions of the judiciary for allocating 3 judges to hear that matter, creating an impression that the urgent application by the president is frivolous, did not deserve to be heard by 3 judges. And I did speak to Mr. Mzwane Lemani, who speaks on behalf of the JG Foundations, asking him what really informed their disquiet, their unhappiness about the court's decision to have 3 presiding officers hear this argument. And he's saying, look, they didn't have to, it's unnecessary. And I asked whether they would accept the judgment should it rule against them. And he was clear that they will not accept a judgment if, according to him, is unlawful and illegal. I don't know what that would mean, but of course we expect that by 9:30, when the court sits to deliver that judgment, we will get to hear from them. Either way, whichever way it goes, as to what they intend to do then going forward.